Now I would like to shift our focus to a very important subject matter. In January 1, the Secure Act became part of our law. And that law affects some of our most important financial resources, our IRAs, our 401ks, our deferred compensation assets. And so I've asked Robert Galliano and Sonny Boren to come and speak to you about the provisions of that act and how that act will affect you and your ability to protect the financial resources represented by your deferred compensation assets, both for yourself as long as you live and for the people you love and care about when the time comes that you no longer need those resources yourself. Robert and Sonny?
We are going to be talking about a subject that is so new. It's law that was implemented in December of last year, and it recently became law as of January 1, 2020. The one thing that I want you to know is that Koppenbarger and Koppenbarger, we are on top of all of the new laws and how they will affect our clients today and in the future. We're going to be talking about the Secure Act. This is an act that was enacted, as I said, recently, and we're going to be talking about how it affects your retirement plans, how it affects, more importantly, the beneficiaries of your retirement plans after you die. The purpose of this act, believe it or not, was to extract almost $16 billion in additional taxes from your retirement plans over the next 10 years to cover the government spending that is being allocated to the benefits that are in the actual Secure Act. The changes that I think are critical to you is the fact that when you transfer one of your retirement plans when you die, most of the time you're going to transfer by beneficiary designation, and your beneficiary will receive it without any benefit of any kind of tax planning, without any planning to protect how that beneficiary is going to use the money or protect it from creditors, and also the fact that from now on, I want you to listen to this, all retirement funds must be withdrawn from the account within 10 years after you receive it as a beneficiary. And that eliminates the lifetime tax-free compounding of income that you would have had you been able to leave the money in the account over a lifetime. And also the option that we all had prior to this change in the laws was for a beneficiary to be able to take little payments over their lifetime, therefore allowing the account to grow, tax deferred, and also allowing you to pay smaller amounts of tax every year. As we know from experience, is that your beneficiaries, when they receive money that they did not work for example, when you leave on the retirement plan that it took you a lifetime to accumulate, most of them will cash it out because they did not earn the money. You earned it, they're receiving it. They could care less if they have to cash it out and pay a large tax bill. And as I had previously mentioned, there's no protection from creditors. Possibly also you may be leaving an IRA to a minor, and possibly you may be leaving a retirement account to someone who may be disabled or elderly, and they will not be able to manage or handle that type of an account. The most important point of the Secure Act for you is that even though the rule is that everybody is going to be inheriting a retirement plan and have to cash it out within 10 years, there are exceptions. What are they? There's 5 of them. Number 1 is the surviving spouse. Number 2, if a beneficiary is disabled. If the beneficiary is a chronically ill beneficiary. Or if it's a minor child of the account owner. And here's another one, kind of tricky, but if the beneficiary is less than 10 years younger than the account owner, they will be exempt from the 10-year rule, and they may be able to, under circumstances, allow to take their distribution over their life expectancy. So, how can we at Cope & Barger and Cope & Barger help you? I'm going to let Sunny tell you how this will be accomplished.
Good morning, everyone. The first thing we recommend is using a trust to meet your specific goals. Now, there's been some errant press out there that trusts are a bad idea. Well, the standard trust might be, but not our trust. In addition, you could start slowly converting to a Roth IRA and hence paying the taxes on it now on a real-time basis. You could finally form a charitable trust. This will stretch out the payments over your entire lifetime, that of you and your spouse generally, but perhaps even a child could be added to get those payments quarterly, even monthly. So if any of you have charitable intent and would like the remainder, the residue of the trust after your lifetimes, after the lifetimes of the beneficiaries, to be transferred to your church or another charity, contact us. That's a very powerful option. And then finally, we have listed on this slide life insurance. What I think of that to be used primarily for, and there are several uses, but that is if you're instructing your trustee to keep all the funds in for one of these healthy adult children, beneficiaries, until the end of the 10th year after your passing. Because at that time, they will have to take it out and there will be a lot of tax due, and that life insurance could come in very, very handy for that. So, some questions. If I'm already taking my RMD, you are not affected. You will just continue getting the same RMDs over your entire life expectancy. However, your beneficiaries will be affected. So if it's going to be a spouse, they get the life expectancy, and then most of the other healthy adult children do not. They just get the 10-year period. The Secure Act rules do indeed apply to Roth IRAs equally. What happens if I don't take the money on time by that critical end of the 10th year in the case of healthy adult beneficiaries? The entire proceeds in the account will be subject to a 55% penalty tax. And if you miss another year, there will be another 50% tax. So we must avoid that at all costs. Trust planning is obviously still a very wise option. We have a standalone retirement trust that can be crafted to meet your individual goals to the best of our ability now under the Secure Act. How I protect my special needs child is a very, very good question. And you will be able to, if you have a law firm of our caliber draft the trust, then you will be able to spread that income over the beneficiary's lifetime, even starting with no income to begin if you wish, by investing in growth securities. And then only after their lifetime will anything pass to the remainder beneficiary of a standalone special needs trust. And finally, the statute is final, but we are awaiting a major number of rules and regulations. So those will be out whenever Treasury gets to it under current circumstances.
Come and see us. We can help you. We are here to help you navigate through these complicated rules. We want to meet with our existing clients to make sure that you have the proper documentation. And very important that we review the designations that you have in your retirement plans. And we are all here and we can help you. we know what we're doing.
Thank you very much, Robert and Sonny. Remember, you can meet with us either in person when this initial restriction on travel and on office visits lifts, or you can meet with us via the use of the internet and the ability we have with Zoom and with Skype to meet with you in person via electronic means. And so keep that in mind. We are introducing that capability to make sure our clients are properly taken care of. Now, Larry and I are going to talk to you about some special provisions that you can put in your estate plan to provide special protection for yourself, your spouse, and for the people you love and care about, your children and grandchildren. One of the things that people don't realize is the term trust covers a multitude of different kinds of legal documents and provisions. And you can have legal documents that range all the way from the form document you can buy at Staples on a disc, and you fill in the blanks with your name and the names of the people you want to provide for, all the way to documents that very carefully provide protection for you as long as you live and have needs, dealing specifically with the circumstances of life that may arise for you, special provisions to protect children and other people who have special circumstances in their life that you may want to provide protection for. And of course, all of this results in confusion for you as a person who is not a trust knowledgeable person. And the problem is that each one of these special protections increases the time and the effort in preparing your document and results in an increase in cost. We at Koppenbarger & Koppenbarger believe that it is our responsibility to make you aware of the protections that are available to you so you can knowledgeably determine whether or not those special provisions are desirable for you and whether the cost of them will be reasonable considering the benefits you get from them. And so I'm going to talk to you, and Larry's going to talk to you about some of those special provisions in the next few minutes. First of all, I want to talk about what some of these problems are before we specifically deal with them as individual problems and individual solutions. Probably the most pressing circumstance that I'm dealing with today in my practice is helping people deal with the problem of the cost of long-term skilled nursing care. In our area, here in Southern California, and this is also true of the Bay Area, it's also true of Sacramento, the cost of long-term skilled nursing care will be somewhere between $12,000 and $16,000 a month. That is a state record and a personal budget record for most of us. And so planning our affairs in such a way that we can receive benefits that we have been working our lifetime to pay for ourselves is an important part of the planning process. And we're going to spend a few minutes talking about how we can deal with our circumstances to avail ourselves of the governmental benefits that we would be legally entitled to. We're also going to talk about potential changes in the law. This deals with potential tax issues, the changes that are occurring in the amount of wealth that we can pass without being subject to estate tax to the people we love and care about when we die. We're going to talk about some of the protections and benefits that are available in the so-called bypass trust, the so-called AB trust. Many people do not understand the protections that are there in that AB provision, in addition to protecting from taxes. We're going to talk about the protections that we can give our children in a trust where we can set up their inheritance in such a way that only they can ever benefit from it. It cannot be taken by a divorcing husband or wife. It cannot be taken by a lawsuit. It cannot be taken by bankruptcy. It can't even be reached by the IRS if the child gets into financial trouble. We're going to talk about trusts that can be set up to deal with people who have special needs, special circumstances, where if you leave an inheritance to them, all you're doing is taking the place of the government benefits they have. And when your wealth runs out, it sometimes means that they are required to spend a year or more requalifying, during which time they have no benefits either from you or from the government. And then for those of you who are pet lovers, we're going to talk about how you protect those very important parts of your life that we call our pets, whether it's a dog or a cat. I recently did a planning for some people who had a horse, and we made special provisions for the care for that horse if the owner of the animal were to pass. And so these are some of the things that Larry and I are going to be discussing with you. At this point, I'd like to start off with a discussion of planning that can be implemented to allow you to legally qualify financially for Medi-Cal benefits. In California, we have a program called Medi-Cal. Other states have a plan called Medicaid. There is a significant difference right now between the provisions of Medi-Cal and the provisions of Medicaid. That difference provides us an ability to protect California families in ways that could not be done in Arizona or in Oregon or in Washington or in any of the other 49 states. And let me spend a few moments talking about some of the things that we legally can do to protect your assets. Now, what I'm talking about is not simple. It is very complicated legal and tax and property planning. But let me tell you some of the tools we have at our disposal to protect your financial resources. First of all, we can protect your home regardless of its value from Medi-Cal being able to seek reimbursement. And that can be done instantly when the Medi-Cal planning is put into effect. But the protection doesn't just stop with your home. If you have rental property or other commercial assets, California lets you transfer those assets not at its fair market value, but at the assessed value that has been established by the county assessor's office. Many times that assessed value is a fraction of the current fair market value, particularly when you've owned that property for many years and have used it as an income producing asset for your financial portfolio. We also have under California law the ability to transfer a significant amount of financial resources on a daily basis where it can be protected from the reach of the Medi-Cal prohibitions. And that amount, I like to use the number of $9,500 a month. It's actually greater than that, but that's a good round number that people can get their handle on to determine how much wealth can be transferred in a typical month and have it protected from Medi-Cal being able to use it to disqualify them from receiving Medi-Cal benefits. If you do the calculations based on a 22-day month, that's almost $200,000 a month of wealth that can be transferred and be protected. The important thing is this kind of planning needs to be done before there's a need for it, because even though we can qualify someone to receive the Medi-Cal benefits even after they are receiving long-term skilled nursing care, this type of planning is not something that can be done in just a few days. Many times it takes several months to get it completed. And if you're not qualified, it means you have to pay for your care out of pocket while the Medi-Cal planning is being accomplished. And so I would encourage you, if this is something that is of a concern to you personally, or is a matter that you're concerned about for someone that is near and dear to you or a friend, that you take the time to share this information with them. In our office, we have a number of people who are skilled at helping in this area of the law. First of all, myself, Larry Kopenbarger, Robert Galliano. We have a team of people set up to help the attorneys get this kind of planning in place. A little bit later, you'll be meeting Jackie Shuchek, who heads up that support team that implements the funding of these trusts and the implementation of them. She has a team of Asia Keys and several other people who are part of her team. And so this is a very important area. It's a very skilled area. I will tell you this, it is an area that very few attorneys and other professionals know can be accomplished. And so it is not something that is widely known and understood. We consider it to be very significant intellectual property, and we do not want to share that intellectual property with other professionals, legal or otherwise. And so if this is something that is important to you, we would like to have an opportunity to share with you personally. We will ask you not to share the details of this planning with anyone other than very close family and friends. On your screen, you're going to see some of the real numbers that the cost of long-term skilled nursing care entails. One of the things that I want to make clear, though, is the kind of planning that Koppenbarger and Koppenbarger can help you with only protects against long-term skilled nursing care costs. It does not provide any significant benefit for assisted living. And so we don't want anyone misunderstanding the scope of the protection we can provide. But certainly if you're in a circumstance or you know other people who are in a circumstance or you're concerned you will become in a circumstance where long-term skilled nursing care will be needed, then exploring the benefits of a Medi-Cal planning trust is something you should seriously consider. And again, we can explore this kind of planning with you in person in our offices, or we can explore it with you via Skype or other electronic means so that this information is available to you. And if it's appropriate, you can engage our services to help you complete it. Now, at this time, I want to introduce to you Larry Koppenbarger, and he's going to talk to you about the benefits of an AB trust. Larry?
Well, Dad, thank you. One thing I'd like to add on the Medi-Cal planning side is there's a lot of misunderstanding that goes on out in the public. Come see us and don't take any action without first talking to us. And that's all I wanted to add on that. Now about the AB planning. What does it mean? What many of you are familiar with is when you talks about an AB trust is one that when one spouse dies, the trust is split into two separate trusts. And for those who don't understand it, sometimes it creates anger. And when James Kosteroff speaks on administration, he may bring this up. But why would it create anger? It creates anger because the surviving spouse is under the impression that they can't do things that they need to do, or they may justly feel that they can't do things that they want to do. And this is the benefit of the AB trust. It guarantees that the planning that is put in place by both spouses, when one spouse dies, the surviving spouse can't disinherit the beneficiaries who have been named and agreed to by the spouses together during their lifetime. So that does lock their hands. But it protects. It guarantees that what is agreed to during lifetime is followed through on. The side benefit of that is it also creates creditor protection. So if that surviving spouse happens to get into financial difficulty and has the IRS coming after them or a creditor coming after them where they have a judgment in place, the monies that are in the decedent side of the estate, the portion of the spouse who died first, cannot be used to satisfy that judgment and cannot be accessed for that purpose. It creates remarriage protection. So if the surviving spouse decides to remarry, they can say to the new spouse, honey, I love you, but the portion of the estate that belonged to the spouse who died first, I can't give that to you. Or they can just be silent and not tell them anything, but just know that what's there in the decedent side of the estate will go to the children of the marriage. Because what do you see when there's a remarriage? If I were to die and my wife were to remarry, is there now a possibility that what we've accumulated will go to a new spouse? Probably not, because with you women, the monies that go to you're more concerned about taking care of your children. But what if Judy is the one who dies first? Is there now a great possibility that the monies that she and I have accumulated over the course of our marriage will now end up going to a brand new spouse and her kids and not to our 5 children? The answer is yes. And look to your own experience. And I guarantee it'll be 90% exactly what I'm describing. That when we men remarry, we end up giving as a way we show our love and affection, we end up giving what we have to our spouse. And basically say to our kids, guys, you're on your own. The benefit of the AB trust is it makes sure that at least half of the estate is not going to go to that new spouse. It is going to stay in the family and be there for the benefit of the kids and the grandkids. The other aspect of the AB planning, this is one that people utilize to say you don't need it anymore. The other purpose is tax planning. Currently, the estate tax exemption is $11.5 million per spouse, which means if you do the math, we have $22 or $23 million that can be protected from federal estate tax. My estate's $5 million. I don't need to worry about estate tax. Well, do you? Under the current law in 2026, that estate tax exemption is going to drop down from where it's at currently to a $5 million threshold, potentially. And if that happens, and you happen to have a $8 million estate or even a $6 million estate, and you die and you have this AB trust, effectively you've protected $10 million. What if someone convinces you to eliminate the AB trust? How much can be protected? Well, in 2026, that estate tax exemption is $5 million. What if your estate is $6 or $7 million? It means that every dollar, or $5 million or more, every dollar over that $5 million threshold will be taxed at least a 50% rate. So if you want to give the government more money, then you can eliminate the AB planning. But look in your own circumstances, sit down and talk with us, and we can determine with you whether it makes sense to keep the AB planning or to do something different. But now you know the benefits of having the AB planning and why when you hear advisors and other attorneys say you don't need it, you may still need it. And let me add one more technical explanation to the AB trust that I would be neglectful if I left it out. Under current law, we have something called portability, which means if you had no planning at all, the surviving spouse can capture the unused portion of the deceased spouse's unused exemption, that $11.5 million. The benefit of the AB planning is it allows you to maximize that and capture it. The other side of it is a property tax issue. When we divide the estate into the decedent's trust and the survivor's trust, we have the advantage in California of preserving $1 million in property tax transfer value. For those of you who have rental properties, that means that instead of having only $1 million that can be exempt from Prop 13's property tax increases, we now can protect $2 million of the property tax value and preserve that for generations. And that is in addition to what we have, the unlimited value that can be preserved for the primary residence. So just keep that in mind.
Thank you very much, Larry. Oftentimes we fail to appreciate what the dollar value of that tax exemption on real property is. On $1 million property, we're talking about roughly $12,000 a year of property taxes that may be able to be avoided by utilizing this tax exemption transfer. And so the AB provision in your trust, even though some financial planners and some attorneys tell you you don't need it, certainly there are a lot of aspects of that that you need to be fully aware of before you decide to eliminate that as part of your planning process. Now, let me shift to some other provisions that I think are extremely important. I'm at the point in life where every year I become more concerned about what happens to what I have when my wife and I are gone, and how that is protected in the hands of our children and our grandchildren and the other people that we are concerned about, charities and other persons. Under the law, we have a very special provision that we can utilize to make sure that what we leave to a child or even to a grandchild is protected, so no one can take that away from that child or that grandchild or whoever that beneficiary happens to be. And we can literally set it up so that the child has the ability to use and enjoy their inheritance, but nobody can take it away from them. I like to describe it as a robbery-proof bank that we create, and we put our child or our beneficiary as the president and the person in charge of that bank, so they can take out of the bank what they want based on the provisions of the protection, which allows them to effectively get the full benefit of their inheritance. At the same time, no one can take it away from them. As a follow-up to the protective trust for children who are competent, capable adults, where you are only concerned about circumstances of life that might occur that they have no control over, depriving them of their inheritance, things like lawsuits, things like divorce, things like bankruptcy. We also have the ability to provide in our trusts special provisions for people who have special circumstances. And what I'm talking about are people who qualify to receive some type of governmental benefit. And all of these governmental benefits are needs tested. And what that means is they look at the financial resources of the person. And if that person has financial resources above a certain level, it disqualifies them from receiving governmental benefits that they would otherwise be entitled to. And so it becomes very important, if we have someone in our life who is receiving SSI or receiving some other kind of governmental benefit, that we arrange our planning in such a way that what we provide to that person supplements what the government provides rather than trying to replace it. As I've said a little bit earlier, one of the problems with trying to replace it is when our money runs out, the government's money doesn't automatically start up. And usually there is a hiatus of something between a year and sometimes longer before the governmental benefits start flowing to that beneficiary again. And so if you have someone in your life who is receiving these kind of special benefits, it's really important that you coordinate your planning for that person in such a way that you don't deprive them of the governmental benefit source by providing benefits to them out of love and affection. You can have your cake and eat it too if you properly plan. Also, remember that there are specialized trusts that we can use to help you avoid income tax and estate tax, and at the same time provide significant benefit to charitable interests that you may have. I'm currently working on a matter where some people are wanting to donate property that has become a burden to them to their church, but they need to receive the income that property provides for as long as they live. And so we're creating a charitable remainder trust that will provide them a readily determinable source of income for as long as they live. And when they die, the property will go to their church as a charitable gift. The advantage of this is they can sell the property through the charitable trust without any recognition of capital gains tax. They get an income tax deduction based on the gift that will ultimately go to the charity, and they get a readily determinable source of income that will be there for them as long as either of the spouses live. And if you're in a situation where you're faced with a sale of property where there's going to be a substantial capital gains tax this may be something that you'll want to take the time to sit down and talk to one of our attorneys about. Also, if you have IRAs and you would like to make a significant charitable gift, that IRA may be a source for that gift, because you can make that gift and avoid recognizing income on the amount of the gift you make to the charity. Again, I would recommend that you talk to Robert or Sonny if you have questions about either one of these types of gifts. So keep that in mind. Trusts are very, very flexible to help you accomplish some of the things in life that you have an interest in accomplishing. And probably one of the things that's most near and dear to our heart is taking care of those beings that God has given to us as companions. And I'm talking about our pets. Many times we don't even think about what would happen to our pets if we were disabled or if we were deceased. And so it's important, if you have animals, that you make provision in your estate planning documents so that they are properly cared for when you can no longer care for them yourself. I have helped people create provisions and trusts for dogs and cats and horses, many different kinds of animals that these people had responsibility for, and we were able to make certain that those animals would be properly protected if they could no longer take care of them themselves. So remember, these are things that the firm of Koppenbarger and Koppenbarger can help you determine what protection is appropriate, and then help you put in place legal provisions to make sure that those provisions are carried out when you can no longer carry them out personally. To reiterate, it is extremely important that you evaluate your circumstances to determine whether or not there is a need for long-term care planning, making sure that you and your financial resources are protected if you have to have long-term skilled nursing care, or someone near and dear to you is going to need that kind of care. We've also talked about the need for special types of trusts with special protective provisions. Again, I want to reemphasize what Larry said about the AB Trust. The AB Trust allows particularly husbands and wives who have long-term marriages to create provisions so that they're protected as long as either one of them live, but at least the half of the one that dies first is protected, so it cannot be changed to go to persons other than the people that the husband and wife desired to provide for before the first one passed away. As we get older, the ability for people to come in and use their influence to get us to change our planning increases significantly. The AB Trust protects the surviving spouse against those kinds of influences. And so it's important for husbands and wives to be aware of that kind of protection. As always, every aspect of your life needs to be evaluated to determine whether some type of special protection or provision needs to be contained in your trust to provide for that area of your life. I've asked Jackie Shuchek to come and speak to you for a few moments about what she and her team do to help the attorneys get the Medi-Cal planning in place and get the clients protected so they're entitled to receive the benefits under the Medi-Cal law. And so without any further delay, let me introduce you to Jackie Shuchek.
I work in the long-term care trust planning area, and I pick up where the attorneys have met with the clients, structured the documents that need to be prepared, and I work with a wonderful team who takes it from there to make sure that everything is done in a very exact way so that the protection we are setting up is going to work when and if there's ever a need to actually benefit by getting benefits from the state of California to pay for long-term care and skilled nursing. The team that I work with most closely is Tara McIntyre, who is a paralegal in our firm, and Asia Keys, who is a legal assistant. Again, every client situation is completely different than anyone else's. And so we always are looking at the family situation, what the clients are trying to accomplish, what their assets are, and making sure that they're fully protected by the time we get through this process.
One of the things I want to spend a few minutes talking about is the importance of leaving a legacy. And many times we think of legacy only in the terms of dollars and cents. But legacy involves a whole lot more than what we have and what we leave behind to the people when we no longer need it. Legacy is our life's values. Legacy is the people we leave behind whose lives we've had an opportunity to shape. Legacy is making sure that the things that we have control of over our lives now are projected into the future so that they bless and encourage the people when we're gone. And so I would encourage every one of you to consider the fact that you have the potential to leave a legacy. I like to tell people someday you will be somebody's ancestor. And if I were to ask you today to hold up your hand, if you would like to know more about some of your ancestors, I'll bet most of you would hold up your hand because we're interested in those people who went before us. Remember, someday you will be somebody's ancestor. And so it's important to leave behind a history of your life and what values and what circumstances shaped your life and how you believe those circumstances and values can improve the lives of the people you love and care about, both now and in the future. And so let me encourage you to take the time to do that. Also, remember that there are certain principles that shape the lives of the people we leave behind. For many years, I've been blessed to be able to help people of significant wealth plan their estates. I don't talk about it because I believe my responsibility is to help every person who has a need that I can help protect the people they love and care about and protect the financial resources they have. But over the years, as I've watched very wealthy people transfer their wealth and their values to their families, I've observed some principles that are consistent in the lives of these people. Number one, all of them valued their spiritual heritage. And I've been privileged. I've represented Christians. I've represented very wealthy Jewish people. I've even represented some very wealthy Muslim people. All of these people, even though their religious practices are quite different, have similar basic moral principles and values. And those families that were successful passed those values on to the children and grandchildren that they had been blessed with. They also had the ability to bring into their families the strangers. And when I'm talking about strangers, I'm talking about people who are not part of the blood family. I'm talking about in-laws. I'm talking about employees. And make those people part of the fabric of the family and the family's heritage. Now, most of us are not people of great wealth, but all of us will have circumstances where we're dealing with strangers in our midst, people who are brought into our lives by the people we love and care about, sons-in-laws, daughters-in-laws, great-grandsons-in-laws, and great-granddaughters-in-laws. One of the characteristics of building legacy is to develop connections with those people so that your life impacts their life in a positive way. Not only will that enrich you, but it will certainly enrich them and will enrich the lives that they will live after you're gone. One of the things that we're dealing with today that we've not had to be concerned about in the past is your digital legacy. That's something that you really need to talk to James Kosteroff about, because this is an area that he's specializing in, is how to help people protect their email accounts, their other digital accounts, so that when they're not able to access them themselves, there are means available so that the access to those accounts can be had by people that you would want to have that ability to access those accounts. And again, the importance of your legacy is that our lives on this earth do not end with our death. Our lives on this earth are perpetuated on through the people who we've had the ability to impact their lives in a positive way. Obviously, our children and our grandchildren and our great-grandchildren are the most important part of that legacy. But the legacy also includes our friends and the other people whose lives have been blessed by us and who we have been blessed by their lives. And so I encourage you to, number one, record a history of your life and the circumstances of your life. Number two, while you're living, express your appreciation for the people who have been a blessing in your life. I once took a course where they said we live in a stroke-deprived world. And by that, they meant we don't get appreciated enough. And I believe that's true. And I think it is really something positive if we will let the people around us who have blessed us and benefited us, let them know how much we have appreciated the privilege of having them as part of our life. And in so doing, we will not only create a legacy, but we will be building a legacy in the lives of other people that they'll be able to pass on as part of their legacy. I want to talk about your legacy. And what is legacy? What does it mean to you? What does your legacy look like? Why is it important, and why should you plan for it? Well, first of all, your legacy is a number of components of who you are. Part of it is your emotional being, who you view yourself and how you view yourself. Part of it's spiritual. It's part of that connection and that relationship that you have with your Creator and His endowing you with life and giving you an opportunity to be the best you can be as part of this life. Now, obviously, we all fall far short of that. But still, it's part of our desire to be the best we can be, both in the eyes of our fellow man and most certainly pleasing to our Lord. And so the spiritual aspect of our legacy is important. The legal aspect of our legacy just means we've tended to business. I've been talking to you for over an hour about the legal aspects of establishing a legacy. Dale spent time talking to you about the legal aspects of your legacy. And so any estate planning you engage in is going to be part of your legacy. And I can tell you from personal experience, how well you do that plan will have a lot to do with whether the people you leave behind bless you or curse you. And so it's really important that when you do these plans, that you do them in such a way that you bless rather than curse. And it's very easy when you're dealing with financial resources to do harm rather than benefits. And so the legal aspect is a very important part of your legacy. Obviously, your finances are part of your legacy. What you have accumulated or achieved financially becomes the financial world that you leave behind to the people you love and care about. But your physical being is also part of your legacy. The Bible says we are a temple of the Holy Spirit. That means we need to take care of this being, this body that God has entrusted to us. That means maintaining it and keeping it as healthy as we possibly can. And then finally, and probably most importantly, on a human level, the relational legacy. Having a good relationship with our spouse, having a good relationship with our children and with our grandchildren, and in my case, great-grandchildren. And I can tell you, after having lived for almost 8 decades, that those relational ties that we have are the most satisfying and gratifying aspects of our life if we have carefully preserved them and protected them. And so every one of us, regardless of where you are in life, whether you're a young person just starting out or whether you're an older person who has much of your life behind you, as long as God has given you breath, it is never too late to work on those relationships you have with the people that are part of your life and that God has made part of your life. Now, what should your legacy look like? Well, I think it's preserving your financial resources. I think it's compiling a family history. I encourage everybody to either dictate in a recorder or on a video camera or in a written form a story of their life, the high points and the things that they have been allowed to experience and achieve in this life that would be a benefit and an educational opportunity for the people they leave behind. That means sharing who you are and the experiences life has brought to you and what you have learned from those experiences. Those of you who are believers have experienced in your life the importance of the values that are taught in the scriptures. We live in a time when there are an awful lot of people, in many cases our own family members, who do not have a good understanding of those spiritual provisions and what the effect of violation of those spiritual provisions have on us as human beings when we fail to recognize those principles and follow them. I'm not going to talk about how you invest or those kind of things. I think if you don't have a good financial advisor, you need to acquire one. We have a firm that's headed by my grandson and by my wife that are involved in financial matters. And if you don't have a financial advisor, one of the advantages of dealing with our firm is they're available to you without cost or obligation to answer questions and give you suggestions as to your financial affairs. But the most important thing is you have someone that you can trust that will put your financial matters ahead of their desire and need for compensation, that they will take care of your needs, that they will act for you in a fiduciary capacity. Now, one aspect of legacy that I think is important, and most people don't even think of it in terms of legacy, but it is important if our society is to continue to have the value systems and for us to benefit from the legacy that has been left to us by our forefathers, that we support those institutions that preserve for our society the values that have made this nation great. In my view, the primary institution that has done that has been the church. I encourage you, as part of your planning, to seriously consider what responsibility you have to support the institution that has had such an important role in your life probably from the time you were born and dedicated through your marriage, through your life, and support that institution. And this is an area where you can sometimes do good by doing good. There are methods available under the laws that allow people, when they make gifts to charitable organizations, to get tax benefits that are quite substantial and quite beneficial. And let me just mention a few of them for your consideration. And let me give examples. Let's say, for example, you have some rental property, and the problems of dealing with the maintenance of that property, dealing with tenants, has reached a point where it is no longer enjoyable for you. but you bought that property many years ago. The cost basis in it after you have depreciated is virtually zero. And if you sell that property, you're going to give to the government a substantial part of the value of that property in capital gains taxes. Well, there's a device that you can use called a charitable remainder trust where you can transfer that property to the charitable remainder trust. There will be no recognition of tax. Quite the contrary, the government will give you a tax deduction that you can use to offset other income based on the amount of the charitable gift that will ultimately be received by the charity. But that's not the best part of it. While you're living, you can reserve the right to receive the income from the property or the proceeds of sale from that property to support your lifestyle for the balance of your lifetime. And the law requires that that amount be at least 5% of the value of the assets held by the charitable trust. So let's say, for example, you had a $500,000 property, you transfer it to the charitable trust, you're going to have to receive by law $25,000 a year as income from that charitable trust, and you can set it up so you can receive it as long as you live, as long as your spouse lives, and you can even provide that it goes income to other family members, although there are some restrictions, and the government will not allow you to totally dissipate the total amount. There has to be at least 10% of the value of the property that goes into the charitable trust that ultimately will go to charity. And so in this case, the rules require that the charitable trust to be set up in such a way that at least $50,000 will go to the charity when the time comes that the trust comes to an end. I realize that this is rather complicated, but what I want to alert you to is that this is a device by which you can increase your usable and spendable income rather than giving the government a substantial amount of the asset that you've acquired over many years. And that asset can be a business, that asset can be rental property, that asset can be stocks or bonds. There is almost no restriction on the kind of property that can be used to put in a charitable remainder trust. There are also charitable trusts by which you can take income producing property and put it in the trust and have the trust pay the income from that property to the charity for a period of years. And then when the term of years is up, the property comes back to you and it becomes your property again. A number of years ago, I was representing an organization called Campus Crusade for Christ, and one of their donors came to me. They owned a very large share of stock in a company called Icy Hot. And you'll see it advertised on the television today. I think Shaq, the former basketball player, promotes it as a spokesman. Well, we took that Icy Hot stock and put it in a charitable lead trust that lasted for 20 years. And during that 20-year period, that income from that Icy Hot stock went to Campus Crusade for Christ to take the gospel to the world. At the end of 20 years, that stock came out of that trust and went back to the family, and the family had it as an asset to pass on to future generations. And so these are some of the kinds of things that can be done with these specialized charitable trusts. Another charitable giving tool that is very effective is donating parts of IRAs or deferred compensation assets. By donating those kind of assets, you don't recognize any tax that has to be paid, and so the charity gets more, and you don't have to be concerned about paying the tax on the amount that you donate to the charity. So these are some of the tools that you can use to provide financial resources to support the legacy of the institutions that have been important in your life. And so I encourage you to consider these things. If you have circumstances where you think these kind of tools could be beneficial to you, don't hesitate to contact our law firm. This is an area of the law that I've been involved in for over 50 years, and I've been privileged to help people give literally hundreds of thousands and millions of dollars to support the kingdom and to perpetuate the value systems that have blessed this country for so many years.